The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Friday, the 27th of May, 2016, are currently trading with gold at $1,212.75 an ounce, silver $16.22 an ounce, Texas crude $49.48 a barrel, and Bitcoin is currently sitting at about 469 U.S. currency. Today in history, the year 1937, the Golden Gate Bridge in San Francisco is dedicated. In construction for over 4 years at the cost of more than $35 million at the time and spanning nearly 2 miles, the Golden Gate Bridge opening celebrations lasted for a week and began today in history. In recent news, a Greek archaeologist, Konstantinos Sismanides, believes he has discovered the tomb of the great philosopher Aristotle. Excavating the ruins of Stagira since 1990, the archaeologist told CNN that his team has strong evidence that the 2,400-year-old tomb belongs to the philosopher. The structure is about 40 miles east of Thessaloniki and is thought to have been built in honor of Aristotle's death in 322 BC. This place was named Aristotelion, and historical sources cite that locals would gather every year to celebrate the life of Aristotle. We know that Aristotle died in Chalcis, an island of Euboea, Sismanides explained, but after some years, they took his ashes and placed them in a bronze vessel. They brought his ashes to his birthplace, the ancient city of Agora, and made an altar in a public building to celebrate Aristotle as a hero, credited with radically transforming many fields of knowledge, particularly in physics, metaphysics, and logic. Aristotle remains a hero of philosophy to this very day. The SpaceX Falcon 9 rocket came down for a perfect landing at sea today during the successful launch of the Thaicom-8 communication satellite. With a flight time of less than 9 minutes from liftoff until touchdown, this landing marks the third drone ship landing at sea for Elon Musk's SpaceX Falcon 9 rocket. This Memorial Day weekend, we not only call remembrance to the nearly 4,000 U.S. military combat deaths in Iraq alone, but the roughly 12,000 suicide attempts by American personnel a year, half of which or more are being successful, and the terrifying estimates of 1.5 million civilian casualties in Iraq since the commencement of Operation Iraqi Freedom in March of 2003. This was Rick Rohde with your lowdown for May 27, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad traits, you go to school and learn the golden rule. So why are you acting like a bloody fool? If you get hot, then you must.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Randy, what have we got going on tonight?
This is Friday, May the 27th, 2016, and yesterday I went to the federal court and I did not get beaten into unconsciousness and thrown under the jail. I did get dire warnings from the U.S. Marshals, but I have to give them credit. The Marshals that I encountered here were more in line with the Texas culture. They were firm and relatively unyielding, but very polite and easygoing at the same time. I enjoyed them. They handled me extremely well. They referred me to the clerk when I came with criminal accusations against Judge McBride, the federal judge in Fort Worth. This is the one that has himself an attitude and rules against pro se litigants without out of hand and without regard for the right of things of the rule of law. Whatever is filed in front of him by a pro se litigant, he will dismiss with prejudice out of hand. Well, I cotched him. He made a boo-boo. Apparently, the U.S. government has not updated the federal website concerning new statutes in a few years because in 2011, the legislature addressed an issue where we had one set of circuits saying that if a case contains issues that are exclusively federal, and issues that are state, and the case is removed to the Fed, then the Fed can hear both the state and the federal issues under the doctrine of judicial economy. And then other circuits said, no, we cannot hear state issues. That's an unreasonable preemption of state sovereignty. So in 2011, the legislature weighed in on the issue to eliminate the split between the circuits. And what the legislature did is they fell on the side of the cannot preempt state sovereignty. They changed 28 U.S.C. 1441C. And it said that while a case with an issue that is exclusively federal can be removed to the federal court, the court must sever the state issues and remand to the state. The Fed cannot hear state issues. Well, if you look on the federal court website and look up 28 U.S. Code 1441C, that change is not reflected there. The change went into effect in 2011 under the it went into effect in 2012 under the 2011 Venue and Removal Clarification Act. Well, apparently these guys don't know about it. And it seems as though Judge McBride didn't know about it. Well, he screwed himself. He screws the U.S. While a private citizen cannot claim ignorance of the law as a defense to prosecution, a public official is held to a much higher standard. And I'm paraphrasing here because it's a little bit longer than this, but essentially what it says on page 109 is it says specifically, if a public official violates a ruling of this court and he be sane, he may not be heard to say he knows not what he does. So, I filed a quiet title action against a property here in Fort Worth. And the opposing party removed it to the Fed. Now, I wrote that quiet title very carefully so that there was only one issue, and the issue was whether or not a document filed with the county recorder met the state filing requirements under Texas Government Code 51901C. So it was very carefully crafted and finally focused on that one issue. The other side removed it to the Fed because they were Wells Fargo and they're a national association, and they think it automatically goes to the Fed because there is diversity of jurisdiction. Well, the problem is they can remove it, but there are no federal issues, so there's nothing for the judge to hear. So instead of filing a motion to remand, that's the normal procedure, I filed a challenge to subject matter jurisdiction. A motion to remand would imply that I'm asking the judge to exercise discretion. I was asking no such thing. I challenged his subject matter jurisdiction, and by the challenge, his subject matter jurisdiction was lost because when the removal was made, there was a presumption that the federal court had jurisdiction. Anytime a case is filed in the federal or in any court, jurisdiction is presumed, so long as the court that it's filed with has general jurisdiction over the subject matter. And in this case, the case was removed alleging a federal question, and this court would normally have jurisdiction over the federal question. However, there was no federal question. So it was my position that the removing party lacked legal capacity to invoke the subject matter jurisdiction of the court, even though the court would normally have jurisdiction over this kind of issue, over a federal case filed in a state over a federal issue in a state case removed to the Fed. He would normally have jurisdiction. But once I challenged it, the presumption of his jurisdiction is abolished. Now he doesn't have jurisdiction, and he must prove it up. So I didn't ask him to remand because remand presumed jurisdiction. I did no such thing. I challenged subject matter jurisdiction and demanded that he sever the state issues and remand them, since there's only one issue and it's state. That left him no option. Well, right after I filed the challenge subject matter jurisdiction, opposing counsel filed a Rule 12 motion to dismiss, which they always do. Since Ashcroft v. Tomley, the court said that it wasn't their intention to raise the pleading standard, when that was horse manure. What they did was create an absolutely impossible pleading standard. If you are a pro se litigant and you file a case in the state court and the other side removes it to the federal court, it makes no difference what you file, especially if it's in Fort Worth. And certainly if it goes before Judge McBride. He will dismiss that with prejudice, out of hand, and he absolutely does not care what the law says, what is right. He just doesn't care. If you're a pro se, he's going to rule against you. If you are a lawyer and he happens to be in a bad mood one day, he's likely to sanction you just because he's old and frustrated and arbitrary and capricious. Nobody likes to go before this guy because they absolutely cannot trust him. So this is Judge McBride. He's should be close to 90 now, and I hear he's planning to retire. I think that's a real good idea. But anyway, he dismissed my case with prejudice. Before opposing counsel responded to my challenge to subject matter jurisdiction. Gotcha. Once I challenged subject matter jurisdiction was lost, and he purported to exercise subject matter jurisdiction before he proved it. That is a procedural due process violation, and it is a violation of 18 U.S. Code 242, official misconduct, in that he denied me in my right to petition the court for redress of grievance, and did so while acting under the color or pretense of an official capacity. I took that down to the court, and they had never seen that before. They assured me that I had to take this to the U.S. attorney, and I assured him that I could find nothing in law that directed a complaint to a U.S. attorney. Everything in law directs a complaint to some magistrate, and I'm here to give this to a federal judge in his capacity as a magistrate. He said, "You want me to give this to a magistrate judge?" No. I want you to give this to a federal district judge in his capacity as a magistrate. So the clerk let me write on the document. He didn't file it. He said, "Do you want me to file this?" Absolutely not. You can't file this. This is the complaint, and it's only the complaint. You can't get jurisdiction until there's a determination of probable cause, and that determination of probable cause forwarded to the court in the form of an order from the magistrate, and then you can have jurisdiction. So he said, okay, then he'd stamp it. I wrote on it for presentation to a district judge in his capacity as a magistrate. He took that. It all went really well. So now we'll see what happens with it. I expect to get a very cordial letter back from some federal district judge advising me that I really need to take this to the U.S. attorney. And when I get that, I'm going to consider that to be legal advice. And when he's giving legal advice, he doesn't have any immunity then. And I'll also accuse the same magistrate of official misconduct himself for failing to perform a duty he is required to perform. And since the federal court is not acting on my complaints, then I bring the complaints back to the state court and file with the state grand jury against the federal judges. We'll see how that works out. Okay, that's my federal judge story, and I'm sticking to it. We're going to go to callers. We had a guest lined up, but we weren't able to contact him in time. So when we come back on the other side, we'll start taking your calls. Do you want to bring us out, Beth?
Sure. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, and give us a call at 512.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
You're listening to Rule of Law Radio. It is May 27th at 8:19. Randy Kelton, Vet Pack. Randy, we're going to bring on some listeners, and we've got some callers on the line. Charles from Washington.
Hello, Charles.
Hi, Randy. How you doing?
Okay, I'm not doing too good. Your mic is distorting horribly. Are you on a headset?
Speakerphone. Let's try and get you off of it. Is that better?
Oh, speakerphone is such a no-no.
I'll get you off of it. I just had you on it because I was writing. Is that a bit better right there?
That's better, but I'm getting feedback.
It might be where I'm located up here on the hill. That might be
Okay, that's better. Now it seems to have cleared up. Okay, what do you have for us today?
Okay, I'm in Seattle, Washington, and I'm the gentleman who's been texting you quite a bit about trying to find another attorney named Sam. I have multiple issues with Seattle systems up here, which is well known. My car was impounded, 6 of my vehicles, because at which time I've been researching the no registering your vehicle, as well as the no having to have a license to travel. And I appealed the tow hearing and proceeded to try to fight my case based upon them me not having to register my vehicle. I'm already getting opposition from the judge. I'm trying to find out, is there anything that you know of pertaining to that in Washington law or rules? Because these are codes and stuff that they're setting.
This is code enforcement and over vehicles. This is really Eddie Craig's area. Yeah, this is really specific, and it's an area I'm not up to speed on. I can give my opinion on it. We've talked before. Did I mention to you about putting a tarp over those vehicles?
I've seen tarps over people's vehicles, and for a long time, they never seemed to get bonded. And then there was one. We always get that one parking.
Well, a tarp would have stopped all of this. I live in a small town. I live right next door to City Hall. I was at an auction, and I kind of got snookered in buying 2 40-foot transport buses. Well, I had one of them out here next to the house, and the mayor come out and told me I had to move that bus. Oh, I do, huh? He said, yeah, you do. It's got to be registered and has to have a safety sticker on it. Okay, he come out the next day, and I have got a tarp over this 40-foot bus. I see him standing out there with his hands on his hip and a scowl on his face, and he stomps off into City Hall. And then I hear Joy. She's a clerk that's been the clerk forever. I hear her cackling like a rooster. And I found out later he came in and asked if, has Randy Kelton been in here checking the ordinances? Yeah, as a matter of fact, he has. Do you happen to know which ordinance he was looking at? Yeah, as a matter of fact, I do. And she showed it to him. If it has a tarp over it, you can't see it. Therefore, it isn't there. Oh, he was furious. But he knew better. He knew better than to talk to me about it. Anyway, but once they have taken it, there is the argument that you are not a city employee, so you don't fall under the corporate rules, because Eddie can make this argument more effectively than me, that the legislature was empowered by the Constitution to write law. But I've never seen a state constitution that authorized the legislature to delegate its lawmaking power. So the question becomes, how does a corporation, a municipal corporation, write law? The legislature cannot empower them to do that. So you'll always notice that city ordinances are never called laws. They're called ordinances. And that's because they're passed by the corporation. So in order for the corporation to exercise jurisdiction over you, you have to agree to the regulatory scheme.
Okay.
Better to call in to Eddie Craig and ask him about that. Once you're already in their system, now you go in there and challenge subject matter jurisdiction. And claim that you never agreed to the statutory scheme, so they stole your vehicles. And you should send a tort letter and notice them that they stole your vehicles without authority, and you have been harmed. Those vehicles were very precious to you, far beyond their actual monetary value, and it's caused you incredible physical and emotional distress. You're having to go into therapy. You're so distressed. Oh, it's horrible. They owe you a lot of money to give you for stealing your cars. But really, I can't give you much more than that because it's not my area of study, but Eddie has. He's done an extensive study on this issue.
Okay, yeah, because I was on the phone last night, and me and another gentleman didn't get to talk with you at the last part, and so that's why I called you back today, and that's what it was. I heard his voice on there, and I was surprised. So that was good because you all emailing you quite a bit.
Yeah, he produced for me last night. Deborah was indisposed, so he was the producer. So we like to jab each other back and forth. So I kind of drug him on the air so we could pick on each other. But normally he'll be on Monday night.
Monday night, yeah, and I have his email, but he hasn't never emailed me back. I know I've gotten a few emails from you that I've already emailed you about on a few things. One was to contact Fred Waldo, which was Fraud Stoppers for Houses, and the other one was the FAM ex-attorney that used to practice up.
Yeah, you're trying to find that lawyer. I've lost track of him. If it was Fraud Stoppers that put me in contact with him, and this was 4 or 5 years ago, and I've completely lost track of him. I do not remember his name. And I would have to go down to about 20,000 emails to find him.
Trust me, yeah. If I knew his last name, then I could easily find him. But I don't know his last name.
Okay, if Frank from Fraud Stoppers couldn't find it, I certainly can't.
Yeah, and it might not be the right person because I did talk to Frank this morning. But other than that, I'll keep on trying because the gentleman that had you on his show some years back, he popped up again, and this time he had an email address, the www. number. So I'll try to locate that again. And I'll keep on trying because it was an important feature. If you heard it, you know where I was coming from with that. And that's
okay. And you might look for David Merland, Myrland, Merland. He's in Washington State, and he's a pretty good legal researcher.
How do you spell Marlin?
Myrland. I pronounced his name wrong all the time on the air, but I did that on purpose just to be annoying. I called him Byron, and he kept saying Merlin. So I was just being annoying. But look for him. He does a lot. He's the best researcher I know of in Washington State.
And that's what I need because I'm trying to find out about this, registering your vehicles. And there was only one attorney who did that back in 90-something. And since then, I can't find it in the codes. The RCs or the WACs. So that would be a good person for me to contact. I do appreciate that.
Okay, give him a call. And tune in on Monday night to Eddie Craig's show.
Okay, will do. Thank you.
Okay. Thank you, Charles. Now, we're about to go to Eric in California, but we're going to go to a break first, so I'm going to back out of here and let Beth have this.
All right, Randy. Get over here. Let me at you. I
ran her off the cliff last time, so she owes me.
Yeah, I'm going to have to speed through. This is Rule of Law Radio. Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
Email is a convenient way to send and receive information, but it can also let advertisers snoop on you. Invisible web bugs in email messages could be monitoring your every click. I'm Dr. Catherine Albrecht, and I'll be back with more in just a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Web bugs, web beacons, pixel tags, and clear GIFs. They have many names, but these tiny invisible image files usually have one purpose only, to track your online behavior. Web bugs are commonly used on web pages, but they can also be embedded in email messages to report exactly when you open a message, the IP address of the computer that read the message, and whether you click on links contained in the message. The best way to fight a web bug invasion is to use a privacy-friendly email service that filters them out. You can also set your email client to block email message images or opt for a text-only email. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
You're listening to the Logos Radio Network at LogosRadioNetwork.com.
Yeah, I got a warrant, and I'm gonna serve them to the head government them.
Prosecute them. Okay. What's up?
We are back. This is Rule of Law Radio with Randy Kelton, Vet Pack, and we have Eric on the line. Randy, can you bring him in for us?
Ready. Here you go, Eric. What do you have for us today?
Okay, so I have a traffic ticket case. It's unsafe speed, and I had already gone through the arraignment hearing, and then I filed a motion to dismiss the case based on lack of subject matter jurisdiction, and I moved to dismiss the evidence based on the fact that it was an illegal traffic stop because it's categorized as a civil infraction in California. And I had the court case on Tuesday, and they never got back to me concerning the motion. They never gave me answers to the interrogatories that I included with the motion. And I filed the interrogatories that Eddie Craig has on his site, the questions concerning civil infractions and, is it lawful for him to stop me and make an arrest, based on that. I included all with the motion, but they never got back to me before the trial.
And they had, okay. Did they have the trial?
Yeah.
Oh, that's a procedural due process violation. That's what I just filed against a federal judge. Procedural due process is a crime.
Right. Now,
so,
how are they supposed to get back to me? Were they supposed to get back to me in writing, or is it just on the day of the trial?
On the day of before they can have the trial, they have to hear all the motions. If they had the trial without hearing the motions, especially challenge to subject matter jurisdiction, they have to prove it up once you challenge it. So what I'm trying to get people to wrap their head around is when you walk into the courtroom, you've got a judge up there, and he wears two hats. One hat's a judge's hat. The other hat is a magistrate's hat. Well, when you walk into the courtroom, you wear two hats. One hat is a litigant's hat, and the other hat is the master's hat. They are public servants. You are the master of those servants. And those servants are there to enforce your law and only your law. If they have another agenda, it is your job to take them to task. And I can assure you it's a whole lot more fun being the master than it is being the defendant. So, you've acted in accordance with law and filed a challenge to subject matter jurisdiction. The judge failed to act in accordance with law and failed to prove up jurisdiction, failed to provide a hearing on the issue. So essentially, he presumed jurisdiction, and the case law says jurisdiction may not be presumed. It must be proven. That is, after jurisdiction has been challenged, it must be proven. So he failed to perform a duty he was required to perform. Now, I don't remember the statute in California, but you got it. The official misconduct statute. And that's a Class A misdemeanor everywhere. Next thing to a felony. You need to file that against the judge.
Okay.
That's your job. Your duty as the master of the servants. File it against the judge, file it against the prosecutor, bar grieve them both, because if this is a municipal court, the judge also has a bar card, and then judicial conduct complaint to judge. They want to file complaints against you, you file complaints against them. In California,
no.
A bar grievance is public. They post these things online.
Right.
So you can have lots of fun with us. We keep saying you never win your case simply because you have the law and the facts on your side. You win your case if you have the politics on your side. I got a ticket in Decatur, Texas. That's the county seat of the county I live in. And they sent me this notice that I had to appear in court last Wednesday, and I goofed up and thought it was Thursday, and I didn't show up at 9 o'clock the way they wanted me to. So I went about 4 o'clock in the evening, and that dirty, rotten prosecuting attorney dismissed my case when I didn't show up. I went to the chief and complained to the chief that the prosecuting attorney refused to take his chicken suit off and dismissed my case before I could get to the fun part. That had nothing to do with law. It had everything to do with the fact that I was fixing to give them a romp through the legal system they were not going to believe. And the chief of police knew full well what I was fixing to do. And he went to the municipal court and told them, you make sure you dismiss this. This guy's going to come after my officer. Politics.
Right.
Does that make sense, Eric?
Yeah, it does, yeah. Now, this
they got this list, they'll put you on if you start doing this to them.
Right, I know. I've heard about that.
Yeah, and the list says, don't pull him over, don't write him a ticket, and don't put him in my jail. We've got a call screener here. He's on the list up here in the Dallas area. And I feel relatively certain that there's no way I can get a Decatur police officer to write me a ticket at this point. Because I'm certain that the chief of police has told his officers what he'll do to them if they do write me a ticket. It's all about the politics. So, what are you going to do now, Eric?
Well, let me describe how it went. At the beginning of the trial, he started asking the officer who did show up on the day, he started asking the officer what led him to issue me a citation on that day, and I objected right then. And the commissioner said, on what basis? And I said, I had filed a motion. I object to you proceeding with this because I had filed a motion to dismiss based on lack of jurisdiction. And this was the only time he mentioned the motion. He said that motion was heard and was denied. And then I said that I also filed a motion to dismiss the evidence because it was an illegal traffic stop and anything that resulted from that. And then he just interrupted me and said that motion was heard and was denied.
Were you there when the motion was heard?
No, I was not. There was no separate hearing. They didn't contact me, via mail or anything like that. There's nothing.
Okay, now it's time to go into stealth mode. Okay. One of the things we suggest is never give fair warning.
Right.
So now you go in and ask to see the physical file in your case. Now, I'm not sure how the law reads in California, but in Texas, the Open Records Act states that the custodian of the record may make no inquiry of the requestor other than to determine his identity and the record sought.
Right.
So, if you can con them into asking you why you want to see this, gotcha. I tend to craft my requests in a way that would make a reasonable person of ordinary prudence wonder, what in the heck is he looking for? So that I can get them to get their curiosity up and then be careless and ask me that question. Once the question is asked, the bell is rung. Now, it's Class A misdemeanor here in Texas, and it's probably the same thing in California because the purpose of open records is to give you access. And if you have to tell them why you want to see it, then they know which records to hide from you. So you're going to have this statute that tells them they can't question you about why you want to see this. So
right.
I'd like to make my request really cryptic. Okay, Vet, you want to take us out?
You got it. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Please call us at 512-646-1984. We'll be right back. See. Hi, you're listening to Rule of Law Radio with Randy Kelton, Vet Pack. Randy, we're talking to Eric. You guys want to continue?
Okay, Eric. So,
yeah.
What was the judge rude, or did he get frustrated or angry, or was he infuriatingly polite? I hate it when they're polite.
Yeah, he was getting really annoyed because I kept objecting, every 10 seconds to something, and he just kept saying your objection is noted and overruled. And when I bring up the motion, he would say that the motion is denied. And then when it came to the part where I asked the questions, I pulled up my interrogatories since I'd never received an answer to them and started asking the officer all those questions. And for more than half the questions, the judge, he just said the court is imposing its own objection based on relevance grounds. And, these are all relevant questions concerning whether the stop was justified given the fact that it was a civil infraction, and how everything resulting from that stop would therefore be illegal and dismissed. But yeah, for more than half the questions, he imposed his own objection. And I said, I object because you are acting as a prosecution. And he said, you're not allowed to object to the court's objections. That's his answer. And he kept rolling his eyes and just getting annoyed at everything. He never raised or anything like that.
Okay, then you can maintain that he denied you in your right to petition the court. Charge him with the procedural due process. And certainly file a judicial conduct complaint against him.
Okay.
This hurts him. They're never going to tell you it hurts him. But this judge has to have a bond to be a judge. And judicial conduct complaints are just like having an accident with your car. Your fault, their fault, nobody's fault. The insurance company does not care. Your rating's going up. Same thing with judicial conduct complaints and bar grievances. You bar grieve that judge, and his malpractice insurance is going to double. You think he's annoyed with you now, you get through bar grieving him, he'll be a whole lot more annoyed. To make sure you bar grieve the prosecutor, you have to understand, these guys are not the sharpest knives in the drawer.
Right.
If they were, they'd be out making the big bucks. But they're down here in this municipal chump court making chump change because they're not making enough at being a real lawyer. So when you sting them with a bar grievance, you got no idea how bad that hurts them. Because if they try to get on with a law firm, first thing the law firm's going to do is check his record. If he's got 2 or 3 bar grievances, they're not going to touch him. Because if they hire this guy with these bar grievances, their insurance carrier is going to jack their rates up.
Right.
So they want to play hardball with you. They want to try to steal your money from them. Let's play hardball back.
Now I have
okay, you have anything? Go ahead.
Yeah, I've got a question about the motion that I filed. Is there anything that I could have gotten wrong in the motion that would prevent them from being required to have a hearing on it?
No. That was a point I was going to address. The judge said the motion was heard and denied. That's why you want to go pull the records and look at the records. You want to see what's in there. You want to find the written order denying these motions.
Okay.
They're not going to be there.
I checked online. They have a case, like docket information, things that you can look up, and it didn't say anything about the motion except that it was received when I filed it. That's all it said.
Did you take it down there? Did they stamp it?
Yes.
Okay, good. If they stamped, if you got a court stamp on it, now you want to go see the physical file.
Okay.
And they're likely to give you some guff about it, and you don't care what their guff is. They want you to look in the computer. The problem with that is when you look in the computer for something you don't expect to be there, when you raise an issue about it not being there, then magically it appears. Randall County, Texas. Randall County is Amarillo, up in the flat, up in the panhandle. I went there and asked to see the physical file because I did not expect to find a criminal complaint in the file. And the clerk said that I could get all of this on the computer. I said, I don't want to look at the computer. I want to see the physical file. I expect something not to be there. And if I look at the computer and then I raise an issue about it not being there, it'll magically appear. So I need to see the physical file so I can verify what is there and, more importantly, what is not there. Because if it's not there, I'm going to give you an information request asking for it. And she said, well, if it's not there, I can't show it to you. So that's right, you can't. Then you'll have to give me a response saying we have no records responsive to your request. And that way I can prove it's not here. Well, I don't have the time or the personnel. You'll just have to look in the computer. Wait right there. don't go anywhere. Somebody's going to want to talk to you. And I opened the door and called the bailiff over and asked him to arrest her. Oh, that was so much fun. And he got his lieutenant, and I told the lieutenant I wanted him to arrest the clerk. Well, you're not going to be arresting anybody here today. And I turned to the sergeant and said, what'd you get him for? He's worthless. I need a real police officer. I am a real police officer. I'm a lieutenant. Oh, you are? You got a card? Yes, I do. Give me that. And I called 911 and asked for an officer to come out and arrest them, both of them. Oh, that was so much fun. Point is, you go to the clerk and ask to see this file. If they give you any garbage at all, you just dial 911. Do not argue with these people. These people are very accustomed to citizens coming in frustrated, upset, angry, and they're very good at dealing with that. What they're not good at dealing with is somebody that they can't affect. And when you ask them to do something and they don't do it, and you pick up the phone, dial 911, now you've done to them what they like to do to you.
Right.
You turn the tables on them. Very likely then they will bring you the records. Or most likely they'll bring them anyway. Generally the clerks are not a problem. But you don't want them to know what you're looking for. You're looking for signed orders. Even if there's an order in there, if it's not signed, it's not an order. If there's an order in there unsigned, then get a copy of it. Certified copy. If there's not an order in there, then put in a written request for any and all orders signed by the judge in this case and give it to him.
Okay.
Now you can because you can state on this day at this time there are no signed orders in this file. And the judge said he heard the orders and he heard the motions and the motions were denied. Well, when did he hear these motions? Did him and the prosecutor get together and hear them ex parte? You don't remember coming to a hearing where these motions were heard. Did the prosecutor file an opposition to the challenge subject matter jurisdiction?
No.
Then he waived an opposition. Give the clerk list the motions that you have, and ask for the order signed by the judge denying this motion and this motion and this motion. And give that, name them specifically so she can come back and say, well, she doesn't have it. You need to be able to establish that. Now you go back and now you file criminally against the judge and the prosecutor.
Okay.
When the judge said in court that the motion was heard and denied, was the prosecutor standing there?
Yeah.
He had if it wasn't heard, he had a duty to notify the judge, and he did not, so he acted in concert and collusion. Charge them both.
Wow.
They are definitely not used to you coming after them criminally, and you will see when you do this. The worm really turns, and if anybody says anything to you like, oh, wow, you need to be careful, you could get in a lot of trouble, that's witness tape.
Randy, we got to go out for a break. Keep it quiet. We got to go. This is Rule of Law Radio. You're listening to Randy Kelton, Vet Pack, 512-646-1984. We'll be right back.
Actually not. We still got another minute.
No way.
Yeah,
you're kidding me. My computer is all messing up. It just refreshed. I'm like, what?
I do that kind of stuff all the time.
Okay.
I forget what segment I'm in. I close the show out an hour early. I hate when I do that. Okay. Sorry about that, Eric. We're still getting these routines down. Okay, Vet, take us out of here. Corner.
Give us a call. 512-646-1984. You're listening to Randy Kelton, Vet Pack. We'll be right back.
It's all according to the will of the Almighty. I read his book and he says he cares not for the unsightly. These warmongers come by that term rightly. I won't pay
We are back with Rule of Law Radio. Randy Kelton, Vet Pack. All right, you guys, go ahead, duke it out.
Oh, I am in such big trouble. I forgot to mute Eric, and we could hear him talking on the intro. Deborah's going to skin me alive. There's only one thing I need to do on the intro and outro, and that's mute the caller. I'm in trouble. Hello, Eric.
Hi. I've got one other thing I wanted to bring up, which is that after he denied everything and ruled all my objections, at the end of the trial, he found me guilty and then asked me if I wanted to attend traffic school. And I said, well, I'm going to be appealing this. And he said, okay, but I need an answer. Are you going to attend traffic school? And I refused to answer it. And then he asked if I wanted to set up a payment plan, and I said again, I'm going to be appealing this. And then he said the court will impose a payment plan and add a fee for that to set that up. And so he went ahead and did that on his own. And then when I took the papers over to the clerk, they wanted to arrange the payment plan, and we asked them about it as well, and said that we're going to be appealing it. And she gave us some information on how to appeal, and said that in the meantime, until the case is over and we've appealed, and we still have to be making payments in the meantime. So
no,
they're expecting us to pay. I know
that is interesting. So they're demanding payments, even though you're appealing.
Right. Even after I've filed, I haven't filed it yet, but even after I've filed it, I'm surprised to hear that they're expecting payments in the meantime. I was really surprised to hear that. Did you
tell them to send you all this information in writing so that you don't forget?
No, actually I didn't. I could probably go do that. That would be a good thing to have on record, I guess.
Okay, you might call down there and say, you guys are saying something about payments? Will you send me some information on that? Then you file a complaint against the court for that.
Okay.
They're attempting to collect a debt that is not yet owed. When you give the court, when you told them you intended to appeal, that was a notice of appeal. And they lose jurisdiction. And that renders the judgment not a final judgment. Okay. The fact that the court ordered the payment plan, I'm going to say that's not an authority that he had. You need to look at California law and see if there's a provision that requires you to pay a traffic fine even if you appeal.
Okay.
It's possible that could be there, but that would be a horrible due process violation. But that doesn't mean they don't have these kind of laws. And if they do have the law, then you need to appeal that issue. Appeal the law is unconstitutional.
Okay.
It inflicts punishment prior to a final adjudication.
Right.
Okay, but look at that. If that's the case, if there is no provision for collecting the fine, then absolutely file against him. And if you have more than one issue that you could say file a bar a judicial, my tongue got tangled. If you have more than one issue for which you could file a judicial conduct complaint, file each one separate and give a week or so between each one. That way they have to treat each one individually, and also do your bar grievances the same way. If you file 4 or 5 things in one filing, they'll treat it as one. But if you do it one at a time, a week apart, then they have to treat each one individually. That'll sting them good. Okay, Eric.
All right.
Have fun.
Got my work cut out for me.
Keep us up to date.
Okay. Thanks a lot. I appreciate it.
Alrighty. We're going to go to John in California. Hello, John. What do you have for us today?
Hello, Randy. It's beautiful out here in California. But listen, I could listen to you 24/7.
Hey, I'm here in Texas where it never rains. The sun always shines. The weather's always perfect.
We've had some.
Oh, you are so full of caca.
What? Wait. No. That's Yankee propaganda.
I love the show, Randy. The information that I'm listening to, I've used some of that information, and it makes a lot of sense. But listen, I've got an issue. Well, not myself. A friend of mine has an issue where he filed a complaint against his accountant, bookkeeper, for embezzlement. And the district attorney, they took up the case, and after 3 years of investigation with overwhelming evidence against the individual, they dismissed the case. And this happened back in 2004. I know the statute of limitations has probably run out. But is there anything that he can do to revisit that case? He's talked to the district attorney before, the new one now, and they said the statute of limitations has surpassed, and he's got no action coming. Is that true?
Yeah. Yes.
Oh, my lordy lord. That's not what he wanted to hear.
Yeah, you need to move more quickly. Murder doesn't have a statute of limitation, but well, I said it's true. I'm certain that it's true. Things like embezzlement, this is not a violent crime. They will generally have a 2 to 4 year statute of limitations. And you're talking 12 years. That's way too long.
Right.
Yeah. Witnesses disappear, memories fade. The guy at this point couldn't get a fair trial. Even if he was guilty of sin, he couldn't get a fair trial. So, yeah, he's probably way too late. But what your guy should have done is you file the criminal first, and in this case, you let the prosecuting attorney do your research for you. And when the prosecutor makes a deal with the guy, and then he drops the case, then you go to the court and collect everything that the prosecutor, whatever investigations, once the case is dropped, then all that information becomes public. It's no longer a work product. And you can get all the information and use that to go after him civilly.
And you know what, Randy? Let me bring you up to speed on that. He did file a civil lawsuit simultaneously. And the judge in the case, by default, finalized the case and close the case.
Did he say he had to state why? Somebody filed a motion for summary judgment, I suspect.
He tells me that the lawyers for the opposition said that they had reached an agreement. Then he said, I read the agreement. I never consented to it. I never signed anything. They went to court on their own and said, we settled. And the judge says, okay, the guy's not here, so by default, I'm going to let you guys have a rule in your favor. So they went ahead and dismissed the case altogether in the civil action.
Yeah, but any default judgment, 70% of all default judgments get overturned. Did they give this guy notice of the hearing?
No, they did not.
That's a standard procedure. That should have got motions for sanctions against the lawyers. They do this, and they get the default in place. Now you have to overcome the default. But 70% of all default judgments are overturned, and the vast majority are overturned for lack of notice.
So is there a possibility, even the case is that old, for him to file a void default judgment?
No, way too old.
Do it right. Way too old. Okay. Then, he's got nothing coming. All right.
Yeah, so I'm sorry, I don't have anything for him, but it's way too old.
Yeah. And you know what? I wanted to verify with you because I've listened to you before, and your information is extremely, extremely positive and extremely effective. And I give you guys props for that because you guys are doing a great job. You'd be surprised how many people are going through the court system. And, I've listened to the last gentleman that talked about his case, and the same thing was happening to me. I went before the judge, and he already knows me by name, and he treats me like with kitty gloves. He doesn't want to bother me. Okay, Mr. Duran, Mr. So-and-so here, Mr. So-and-so here, and thank you there. But let me ask you one more question while I've got you on the line. When they give you in California a notice to appear, isn't that a notice to appear before the judge? Because it says right on the notice to appear before a judge or a clerk. And the day I went to court, I was not on calendar. And
have you read the rules of criminal procedure for California?
To that extent.
Look up. Okay, here's when they give you that notice to appear. I had one on my citation. It says it's supposed to appear before the court, but I looked up the code, and in Texas Transportation Code. Section 543, I believe, 003, 4, 5, and 6 are the ones that authorize the officer to release a person on a promise to appear. But the promise to appear under 5006 is to appear before a magistrate because the law requires that any time a person is arrested for an on-site offense, they must be taken directly to the nearest magistrate. Now, the magistrate may be a judge, but when you step before him, you don't step before him in his capacity as a judge. You step before him in his capacity as a magistrate. And it is his duty first to determine whether or not probable cause exists to believe that a crime has been committed. So when I went in, a clerk wanted to take a plea. Well, the clerks were so nice and friendly, and I couldn't get them off their game. So I left them be. But we have a clerk here trying to take a plea. Well, the question is, what authority does the clerk have to take a plea? Let me give you some Texas law, then you're probably going to have some California law that mirrors it. Rule 413 of Texas. Oh, I'm sorry, I'm looking at the wrong one. When a person is arrested for an on-site offense under 14.06 Texas Code of Criminal Procedure, the arresting officer is required to take the person directly.
Okay, Randy, I'm going to have to do it again. I swear this time I'm right, though. So it's Rule of Law Radio.
This is the Logos Radio Network.
Ain't gonna blind me. Don't bore me.
We are back. Rule of Law Radio. Randy Kelton, Vet Pack. All right, go ahead. Continue. I won't cut you off this time.
Okay. 14.06 Texas Code of Criminal Procedure. You're going to have something similar in California. There has to be a provision authorizing a police officer to arrest for an on-site offense. And according to the federal requirements, you must be taken before a magistrate. All of the states except 3 adopted the model penal code put out by the American Bar. And they ask all the states to adopt this model code so that everybody's code would be similar, so that if you go from one state to another, you can be pretty sure if you're in compliance with law or not. So most anything that I have here in Texas, you'll have something similar in California. And what 1406B says, a peace officer who is charging a person, including a child, with committing an offense that is a Class C misdemeanor other than an offense under Section 4902 Penal Code may, instead of taking the person before a magistrate, issue a citation to the person that contains written notice of the time and place the person must appear before a magistrate, the name and address of the person charged, the offense charged, and the following admonishment in bold-faced and underlined type if you are convicted of a misdemeanor offense involving violence. I won't go into all that. That's okay. 1403 requires that if a peace officer arrests you, 1406A. 1406A says if a peace officer arrests someone for any reason, they are to take them directly to the nearest magistrate for an examining trial. While in Gerstein-Pugh, it says that an arrest for most people is a traumatic experience. And while it would be better that all arrests be made on an existing warrant, it is a reasonable compromise to authorize an officer to arrest for an on-site offense. And while the officer has authority to make the arrest, to hold the person for a reasonable amount of time in order to do those things concurrent with arrest, in order to ensure the safety of the arrestee and prevent escape. Once those goals are accomplished, the authority of the officer to hold evaporates. He must get the person before a magistrate for an examining trial, and the magistrate must make a determination of probable cause. Now, in a Class C misdemeanor, they can have you sign a promise to appear before that magistrate for the purpose of the examining trial, not to enter a plea. Enter a plea in Texas. It's an arraignment hearing. An arraignment hearing under Texas Code of Criminal Procedure 2601 is a hearing for the purpose of determining the accused identity and taking a plea. That's an arraignment hearing. However, 2602, an arraignment hearing can be ordered in a felony offense after indictment or a misdemeanor offense punishable by imprisonment. So the legislature specifically excluded an arraignment in Class C misdemeanors. So, what are they ordering you to appear to court for? Under what authority? This goes to the presumption that you, as the master of the servant, can do anything you want to, unless you, through and in conjunction with the other masters, have grouped together and had your legislature pass laws that specifically restrict you in certain rights. We've agreed that we won't allow one another to kill each other, to steal from each other, and various other things. Anything that you are not specifically forbidden to do, you may do as your right. A public official, on the other hand, may not do anything unless the law specifically authorizes him to do so. So the question is, the one I posed to the federal court today, or yesterday, well, you have to take that to a prosecutor. And I asked the clerk, well, where'd you come up with that? I can't find that in law anywhere. And he just stood there and looked at me like, duh. I never thought of that. I said, yeah, you can only do what the law specifically authorizes. So, John, where did the court get authority to do what it did?
They don't.
You don't want to hear this. Well, that's policy. Well, you can use your policy for toilet paper, Bubba. I just filed against the Texas Ranger for following policy. You follow policy, I'll follow law. We'll see how this works out for you guys. So
yeah, well, I'm right on them, and go ahead, Randy. I said I'm right on them, and I'm going to stay on them because I think I got a great case. It's just a telephone. He accused me of allegedly being on the phone when I wasn't. But anyway, I'm right on him. And I'm going to stay on him. I've done this before, and listening to you guys is a great help. Oh,
wait a minute. He accused you of being on a cell phone?
He accused me of being on a cell phone. I showed him my log, and I said that he verified the times and said, hey, here's the times. I said, look, my last call came in unanswered because I was driving. I said, it tells you right there. I said, what time did it come in? And he verified the time. He goes, yep. And he verified the time he called it in. I said, and it's just 1 minute now after. I was on the cell phone. And so he says, well, explain it to the judge. I said, I will explain it to the judge, So I'm not going to argue. I'm not arguing either,
So he had knowledge when he wrote the citation that the citation was invalid.
Yeah, absolutely.
Ooh, tampering, perjury, official oppression, or in California it would be official misconduct. They don't realize how these things stack up if somebody pays attention to law. I suspect my judge just got no-billed yesterday. I hadn't talked to the prosecutor yet. But he had a bailiff touch me, and I charged him with first-degree felony aggravated assault. So, you want to play hardball, Bubba? I introduce you to the deep end of the pool. They don't realize, they don't read their own codes. So they don't understand how serious it can get. And it's your job to introduce them to that.
And I said earlier, some of these judges don't even know what the heck the law is. They don't even understand. They don't even know it themselves.
Yeah, and if they don't know what the law is, they're screwed. Are you familiar with Screws v. U.S.?
No.
Write it down, Screws v. U.S., and look it up. I read that and almost couldn't believe what I saw. If a public official violates a ruling of this court, and he be sane, he may not be heard to say he knows not what he does. The first question I want to ask the officer when I get him on the stand, are you insane? Objection. Then I bring up Screws. And every time but one, I got the objection overruled. I need to know he's not insane so I can hold him to the rule of law. Not only did they say you have to know the law concerning your profession, you have to know all of the court cases concerning your exercise of your authority. That's why I was so surprised at what I saw in Screws. You really need to look that one up. It's a wonderful case. It's a 1943 case, and it is still good law. Okay, we're about to go to another break. Do we have anything else for you, John?
No, you've been very helpful. Thank you so much. And you guys have a beautiful weekend.
Okay, you too.
And I'll keep listening to you guys.
Okay, thank you. Okay, Vet.
Got it. This is Rule of Law Radio. This is Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back.
Move over beef, lamb, and pork. There's a new kid on the block, and it's taking America by storm. I'm Dr. Catherine Albrecht, and I'll be back in just a moment with a tender, juicy morsel on the latest in carnivore cuisine.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
It's lean, it's trendy, and it isn't half bad. Goat meat. It's fall off the fork tender and buttery when it's properly marinated and grilled or braised, and it's not gamey. In fact, some gourmets say goat meat is perhaps the most flavorful meat on the planet. Word's gotten out, and goat meat, also called chivon or cabrito, is finding its way to the menus of high-end U.S. restaurants, and it may soon be at your local grocery store. Goat meat may be new to Americans, but it's long been considered a staple of third-world countries. In fact, it's estimated that 63% of red meat consumed in the world is goat meat. No kidding. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Chemtrails.
Looking for some truth? You found it. LogosRadioNetwork.com.
You're listening to Rule of Law Radio with Randy Kelton, Vet Pack. We are back and we want to talk to Deborah. We've got Deborah from Texas. Deborah, what's going on with you?
Hi.
Hi.
Hi, this is Deborah. Are you there?
Go right ahead.
Hello? Okay, I didn't. Hi, Randy. I had filed a quiet title action on April the 4th, and I had filed that because there was, what do you call it, like the statute of limitations had ran out on my quiet title. I've been emailing you, so I'm the one that you probably have seen the emails from. But anyway, so I filed the quiet title. I waited my 20 days, which is actually 21 days, and the bank filed, they didn't file an answer. And then it's been another 27 or 28 days since that, and they still haven't filed an answer. And then I tried to go to court like 3 times or 4 times to meet with different judges, and every one of them has an excuse why they won't file or why they won't sign my default judgment. And the court that I'm assigned to, I actually went there on Thursday and here in Denton County, and he told me, he said, let me have your phone number, and he says, when I get some downtime, I will read over your order and your case. He said, but he says, it doesn't mean I'm going to rule for you. It just means I'm going to look it over. And he said, also, let's see, there was something else. He said he would have his administrator call me the next day and let me know what he decided. So, it's kind of a cut and dried default judgment, and he never did. He never did, sign it. So anyway, so I got home and I checked to make sure that some other documents that I had filed in the case were online. And then all of a sudden, when I go online, I see that suddenly there's now an attorney assigned to the case, and he's filed an answer. And it's been since they should have filed their answer by April the 28th, and they didn't.
Okay, here's the deal.
Yeah.
The vast majority of all default judgments are overturned, and for one primary reason: lack of notice. Mm-hmm. So you come in as a pro se litigant, and you hand a petition for default judgment to the judge. The first thing he's going to say: did this pro se litigant give proper notice? Do you have the signed green card?
Yeah, the clerk served them. I paid the extra money to have them do it. To have the district clerk serve them. And they wonderful.
What he wanted to do probably was check all the facts to make sure everything was in order. Now, if you were a lawyer that's been in front of him 100 times and you hand him this default judgment, he's just going to sign it. Because if you screw with him as a lawyer, he can wind your clock, and he pretty well knows who will mess around and who doesn't. But since he doesn't know you, he probably wanted to check. And the reason there's an answer in there is he probably had his coordinator contact these people and say, well, you probably noticed. And then they did some, oh my goodness, we screwed up. But sorry, Bubba, too late. They filed an answer, you filed a motion to strike the answer.
Okay.
Yeah, and so it was the judge being reasonable. And since the court actually served, they can't claim they didn't get service. So what they are likely to claim is excusable error. But you didn't file the next day. You didn't file on the 22nd day. You waited a while. So it's going to be very difficult for them to justify excusable error. So,
is there anything I can do to make sure that they don't try to prevent me from getting my default judgment? Or
this answer is an attempt to prevent you from getting your default judgment. File a motion to strike the answer as untimely.
Okay.
The courts don't like default judgments. They don't like to rule against a party without the party having opportunity to mount a defense. But if a party doesn't take the court seriously and lets his time run, you have a right to the default judgment.
Mm-hmm.
So, whatever they do, keep in mind your only purpose in the trial court is to set the record for appeal. If you've got them dead bang on limitations, well, this would actually go to laches.
Mm-hmm.
Maybe not. Laches is where you have a right and you sit on your right. But one thing that's included with laches, if you claim laches, you have to be able to show that your situation changed in the interim when the other person didn't exercise their right. But that's kind of an aside. You have a right to the default judgment because they were not timely, and they would have to show excusable error. And about the only excusable error is that it was served in the wrong place or to the wrong party. But if they served it to a law firm that purportedly represented the client, or they served it to the client itself, then they can hardly make that claim. The fact that the court, that the marshals or the constable served it does not perfect the service, because the constables can screw up. Mm-hmm. And you can't hold the client or the defendant responsible for a screw up on a part of the court. I don't like constables doing my service for me.
Well, they did at USPS with a certified mail green card.
That's the way I like it done. Okay, so if they did at USPS, where the court may not trust a particular constable, they do trust the U.S. mail.
Yeah.
And so anytime you have them serve, you should also serve. Just to make sure, because a lot of times you'll notice you get a copy regular mail and a copy in certified mail. Mm-hmm. You know why that happens?
Why?
The reason that happens is that the court may say, well, it's possible that the U.S. mail screwed up once,
mm-hmm.
but not twice. Not 2 times on the same address. Never happened. The U.S. mail does screw up on occasion. UPS or any of them will screw up on occasion, but it's rare. So if you send 2 of them, send them in separate ways, one certified, one regular mail, the court's going to say, they might have missed one, they're not going to miss both. So they'd have to prove they didn't get it. So that's why you get 2.
Well, the statute of limitations was up on the collection and all of that stuff anyway. So, for them to hire an attorney here at the last minute was kind of like, throwing good money after bad, basically, because there should be no way that they could win when the statute of limitations is out.
Let me make a suggestion.
Of the letter of acceleration. Uh-huh.
Yeah, you might bar grieve the lawyers. You look at their answer. You move to strike the answer.
Right.
But look to see if there is anything in the answer that would have the appearance of failing to speak with candor to the court. That'll get a lawyer hammered pretty often. May the 19th, the federal court just hammered the U.S. attorneys big time over an internal revenue issue. The federal judge ordered that every U.S. attorney in the Fifth Circuit take a 3-hour course every year in ethics, and ordered that it be an in-person course. It can't be done over the internet. Bet?
Randy, we're about to have to take a break. Here we go. We're with Rule of Law Radio. You're listening to Randy Kelton, Vet Pack. Call us at 512-646-1984. We'll be right back. Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. It's good and funny to follow you. Yeah, little Jerry, sin reality.
We are back with Rule of Law Radio. Randy Kelton, Vet Pack, and we're listening to Deborah from Texas. Deborah, was there anything else that you needed some help with?
Oh, yeah. Yeah, I had one more thing. Randy, what do you think about me filing an FDCPA lawsuit against the bank and the attorney for, trying to collect on an unenforceable debt?
I think that's a great idea, but I wouldn't do it yet.
Okay.
Wait to let them never interfere with someone when they're screwing up.
Okay.
They're trying. let them dig a little deeper hole for themselves. I would go ahead and adjudicate the quiet title. That's a nice pawn move. And what you can expect them to do is file a removal to the federal court. Are you in Dallas? Are you in the Dallas side or Tarrant County side?
I'm in Denton County.
Oh, Denton County. Oh, okay.
Yeah.
I haven't annoyed Denton County in a long time. That'll put you in the
when you were talking about
Dallas side of the federal court.
Yeah.
Yeah, and it may get better. I just filed criminal charges against a federal judge in Tarrant County for dismissing my quiet title action.
Mm-hmm.
I maintained they removed it to the federal court, and I maintained he had no jurisdiction. I filed a challenge subject matter jurisdiction. The other side filed a Rule 12, and before the other side answered my subject matter jurisdiction challenge, the judge dismissed the Rule 12. He dismissed on the Rule 12 with prejudice. Got him. He stepped right across the line. So I've nailed him. And this is likely to kind of reverberate through the courts. They're not used to somebody coming after them criminally. So you might get them listening a little more. And I would certainly look at these guys. If they fail to speak with candor to the court, for instance, if they make a claim that's not valid or not supported by the facts, bar grieve them immediately.
Mm-hmm.
What'll wind up happening after 2 or 3 bar grievances, you'll find you get another law firm. Because this law firm says, man, I'm out of here. She's kicking my behind. So they split and they hire another law firm, and the other law firm is going to cost them 2 or 3 times as much.
Oh, wow. Well, you wouldn't recommend me sending him a letter of notice of intent to sue because he's violating FDCPA stuff?
No, not yet. At FDCPA, you don't have to give him a tort letter.
Okay.
Yeah, you can sue him directly, but I wouldn't do it yet. He probably hadn't screwed up enough yet.
Well, I was hoping they would withdraw and the judge would just go ahead and sign the order, ideally. You're in a position to where you may actually get your default. I certainly wouldn't poke this bear. I wouldn't stir things up until we get a ruling from the judge. Okay.
If the judge rules against you, then you can file an appeal. You can bar grieve the lawyers, just land on them with both feet. And depending on what their answer says, you may be able to go after them for that.
Okay.
Question: How did you calculate the statute of limitations?
After the letter, 4 years after the date of the letter of acceleration.
Perfect. A lot of folks think when you stop paying the mortgage is when the the clock starts. But no, you are exactly right. When they file a notice of intent to foreclose, that starts the clock, and they cannot unstop it unless they do a modification or stuff and reinstate the loan.
Yeah.
What happens is they run out of time, and then they try to come back and foreclose anyway. We had one, I have a friend that was a HELOC loan, so they went to the court, and they got an order authorizing them to foreclose. Well, I had filed a petition and intervention, and this is the same judge I just filed first-degree felony aggravated assault against. He hates me. So I came in with a challenge subject matter jurisdiction and a petition and intervention, because I had a mechanics lien on the property, and he threw me out of the court. He ordered me behind the bar. So instead of going into the gallery, I walked out of the courtroom, and as I'm leaving, I turned and looked back, and this young little smart-mouthed little lawyer is looking at me leaving the courtroom, and he's got a really disturbed look on his face. He got his ruling, but he knew it was garbage. So he didn't do anything with it. A week after the 2 years they had to evict was up, another lawyer picked up the case and filed another petition for expedited foreclosure. See, they tried to start it all over again and restart the clock.
Yeah.
Not. The judge had already issued an order in the case. 30 days after he issued the order, he lost plenary jurisdiction. That goes to collateral estoppel. They can't come back.
Yeah.
In your case, they're collaterally stopped from trying to foreclose.
Right. Well, the reason that I had started doing, trying to find out who owns my note and all that kind of stuff, which got me to where I'm at now. My sister had bought up in Bonham. She had bought some acreage, and she financed it. She made all of her payments, and then when she made her last payment, a couple of months later, she gets a letter in the mail from somebody claiming to be an investor, and they told her that now that she's paid the bank off, she has to pay them, and that none of that money basically went to them, and so now she has to pay them, and they gave her like 10 days to pay them like $25,000. Or they were going to foreclose on her property. And so I was like, oh, my God, that's my note,
Did she have a title
she
company?
Passed away. Yeah, I don't know. I don't know what she did, but I do know she went and borrowed money to pay them. But that's how I got into she's passed away since then. But she, she was like really shocked that, how all the banks and everybody has gone through all that mortgage fraud. And I think a lot of people are going to be looking at, I hired a investigator, and he found out that they had made 76 copies of my note and sold it off 76 times for the derivative. And so who do I pay? Who's the right person? So
76. Was he able to trace them down?
Yeah, I've got them. I've got copies of them. I've got Bloomberg printouts of everything, and got all that here. I just, it's like judges don't want to look at it. This is my second quiet title on my property, because the first time they bumped it up to federal court and did the federal question and all that garbage. But
if they do that again, if they try that again, get a hold of me. I'll write you a subject matter jurisdiction challenge.
Okay, but it's just been...
And they won't like that. Or write down 2011 Venue and Removal Clarification Act.
Okay.
That changed 200 years of law. And it denies the federal court jurisdiction to rule on a state issue, period.
Yeah. So I had stopped making all my payments because I didn't want to pay the wrong person. With all of that, how many people could come back after I paid off my mortgage?
Have you looked in the public record and followed the chain of title in the public record?
Yeah, they're all over the place. There's Leslie and I checked it all out. We wrote it all, put it all in an Excel spreadsheet, and it's all over the place. And there was one company even filed a forgery that they backdated 10 years to try to take my property.
Did you sue that company?
Do what?
There's a special statute in Texas. It's a fraud statute. I think it's Civil Torts and Remedies 139, I believe. But it's specifically for someone stealing or trying to steal convert real property.
Mm-hmm. Yeah, there's another company here that got involved with that company, and they They actually backdated something 10 years ago. And they did the first in time, first in line. They came before MERS, and Countrywide conveyed it to MERS, and then MERS conveyed it to Bank of America, and they went back and put themselves right between Countrywide.
Yeah, but when did they file the document in the record?
April of last year.
Okay, that's when it counts. Any claim against real property not properly acknowledged or proven and filed in the record is void as to the holder. Their claim was void until it was filed. So it lands in line when it was filed, not the date they happened to put on the document.
Right.
The date's irrelevant. But that should actually get criminal. You should pursue criminal charges just for yucks.
Yeah, we were talking about doing that.
Okay, send me an email on that, and I'll look up the statutes for you and send that back to you.
Awesome. Okay, great.
Okay, is there anything else today?
No, I think that covered it. I was just wondering what my next plan of attack was.
Okay, be patient with the judge. Give him a chance. He may actually rule in your favor.
Yeah, I just thought it was really odd that he, as soon as he found out about that there was nobody fighting that, all of a sudden an attorney popped up from Houston. It's just really strange.
Okay, hang on. We have to go to break.
Okay.
Okay, thanks. We're going to move on when we come back. Go ahead, Vet. She's got her mic turned down again. We'll be right back.